Are we good, Donna? I think that was a shaking of the head. Yes, sorry. I can't hear anything. I don't know if you said anything.
Yes, we're live.
Okay, thank you. Just needed confirmation. Good morning, everybody. So our chair sends his regrets for today's meeting, and also sorry that I'm not there in person with you. But therefore, prior to commencing, we'll need to first appoint our acting chair for today, and Honoree has offered once again to fill this position. So I'll first read the resolution, and then we can commence with the regular meeting. Moved by Jean Neville, seconded by John Agate. Be it resolved that Honoree Tall is hereby appointed as acting chair to preside over the Committee of Adjustment meeting held on July 27th, 2026. And I guess I'll say all those in favor. And that's carried. And I'll pass it on to you now, Honoree. Thank you.
Morning. I would like to welcome everybody to the hearing today. Meeting is called to order at 9:31 a.m. Today's proceedings are being held as a hybrid meeting by way of in-person attendance and teleconference to hear minor variance applications PLMB 2026-033 and PLMB 2026-034. The Committee of Adjustment is appointed by Council to consider applications for minor variances to the zoning bylaw pursuant to Section 45 of the Planning Act. The Planning Act requires that a public hearing be held. The public hearing serves two purposes. First, to present to the Committee of Adjustment and public the details to the application, and second, to receive comments from the public and agencies before a decision is made. All submissions form part of the public record. Any applicant, agent, or member of the public wishing to address the committee for a specific application is reminded that presentations are limited to 10 minutes per person. All parties will be verbally acknowledged before being asked to proceed. For those attending by teleconference, if at any time you're having difficulties hearing what is being said, please say so or click the raise hand button or dial *9. We kindly ask that everyone speak slowly and clearly when addressing the committee. If you are of the opinion that holding the hearing as an electronic hearing is likely to cause significant prejudice, we ask that you advise this committee at the earliest opportunity and the matter can be addressed accordingly. At this time, I will ask that anyone who objects to an electronic hearing of the matter on today's agenda or is having difficulty hearing what is being said, please click the raise hand button or dial *9. Have anybody? Thank you. The committee will first adopt the agenda. Would the Secretary Treasurer please read the resolution?
Through you, Madam Chair. Moved by Paul Riddall, seconded by Jean Neville. Be it resolved that the Committee of Adjustment hereby approves the agenda of the July 27th, 2026 meeting as circulated.
Carried. Do any committee members have a pecuniary interest in the applications being heard today? No, thank you. There are minutes to approve from the June 22, 2026 meeting. Does the committee have any comments or questions? Thank you. Would the Secretary Treasurer please read the resolution?
Moved by John Agate, seconded by Paul Riddall. Be it resolved that the Committee of Adjustment hereby approves the meeting minutes of June 22nd, 2026 meeting as circulated.
All those in favor? Thank you. It is carried. I now declare this to be a public hearing for application PLMB 2026-033, located in part Lot 18, Concession A, Geographic Township of Minden, 1220 Bobcaygeon Road. Would the planner please summarize the proposed variance and any correspondence received to date regarding this application?
Thank you, Madam Chair. So I'm playing two roles today, Secretary Treasurer and Planner. So I'll put my planner hat on for now. So through you, the chair, the township received minor variance application PLMB 2026-033 from the property owner, Karen Gustafson, for 1220 Bob Cajun Road. The property is developed with a dwelling, and the owner wants to construct a one-story detached additional dwelling unit. The additional dwelling unit is proposed to meet all requirements except relief from the zoning bylaw is required from section 4.21 to permit an additional dwelling unit to have an increased setback from the primary dwelling of 50 meters, whereas an ADU or additional dwelling unit is otherwise required to be a maximum of 30 meters, not minutes, 30 meters from the primary dwelling. The application is subject to 4 tests of the minor variance, which I'll review briefly. So the first is whether the application is minor in nature. The proposed increased separation distance is a result of site constraints. However, the proposed location will be further from the front line or from the front lot line and behind the existing residential use, as well as smaller in size, and therefore the proposed ADU would remain accessory to the primary dwelling. Further, as lot line setbacks are being exceeded, no impacts to neighbors would arise. The application is therefore found to be minor in nature. For the second test, is the application desirable for the appropriate development or use of the land, building, or structure? The accessory use is consistent with development in the surrounding area, which is also developed for rural residential uses. Existing conditions, including the locations of the septic system, the driveway, a pond, and wetlands, limit the area available for development within 30 meters of the primary dwelling. The proposed location supports an efficient site layout, retains existing vegetation for natural screening and privacy, and remains close enough to the primary dwelling to allow for shared utilities and servicing. The location also provides an increased separation from the adjacent pond and wetland features to better support the protection of natural heritage. The application is found to be desirable for the appropriate development or use of the land and building. The third test is the application uphold the general intent and purpose of the official plan. The subject property is designated rural on Schedule A to the Township Official Plan, which permits ADUs. Part of the property is recognized as having secondary aggregate resource and is further designated in part as mineral aggregate resource. The subject property and property directly south are also identified as existing licensed aggregate operations. Section 3.3.5.2 of the official plan does direct that residential development should not be located in proximity to aggregate or other related resource industry uses. However, the residential use is already established and the additional dwelling unit is considered accessory to that. Therefore, the policy direction is not directly applicable. However, no impacts to the surrounding aggregate resources or land use compatibility are anticipated. The on-site the on-site license is being surrendered, and also the pit, which is on adjacent lands, exceeds the setback required by the official plan policy. The proposal is for a detached building, smaller in size, and to be located further back from the township road than the existing primary dwelling. Section 519 also identifies that additional dwelling units shall not be located within hazardous or environmentally sensitive areas. As noted, the proposed additional dwelling unit will be located well outside of the property's natural features, and the on-site aggregate license, as mentioned, is being surrendered. The application is therefore considered to uphold the general direction and purpose of the official plan. Lastly, does the application uphold the general intent and purpose of the zoning bylaw? The subject property is zoned rural and hazard land on Schedule 7 of the zoning bylaw. The additional dwelling unit will be entirely within the rural zone and will meet or exceed all development standards for an additional dwelling unit, except for the proposed separation distance. As per the zoning bylaw, the ADU is required to be located no further than 30 meters from the primary dwelling. The intent of the 30-meter separation distance is to ensure that the ADU remains clearly subordinate to the primary dwelling and that it maintains an accessory nature while still providing an additional independent housing opportunity. Although the proposed 50-meter setback exceeds the permitted maximum by 20 meters, That additional distance is relatively minor given the size of the property and responds to existing site constraints. The additional dwelling unit remains close enough to allow for shared utilities and servicing. The increased separation accommodates the site conditions while maintaining appropriate setbacks from lot lines and maintaining natural features, as well as the character of the rural area. Given the foregoing, the application is considered to uphold the general intent and purpose of the zoning bylaw. The application is also required to be consistent with the provincial planning statement. Under policies of the PPS, the subject property is rural area, more specifically rural lands. The PPS supports development of accessory dwelling units through gentle intensification to provide a range and mix of housing options. The application is therefore considered consistent with the PPS. Notice of the application was circulated to neighboring landowners and commenting agencies in accordance with the statutory requirements of the Planning Act on July 16th. We did receive comments from the Ministry of Environment indicating that they had no comments, but otherwise no comments have been received. Therefore, it's recommended that application PLMV 2026-033 be approved subject to the conditions that are outlined in the report.
Thank you. Is the applicant or property owner here today? Would you kindly step up to the desk? And please state your name for the record and provide any additional information you would like to present to the committee.
My name is Karen Gustafson, 1220 Belcage Road. Basically, everything's been covered. I love my property. I promise to take care of everything there. I don't know what else to say. I'm grateful to be able to do this. I need to retire, and this was my solution to be able to rent out the big house and live in a small house. And that'll cover my my bills. So I'm looking forward to this new venture and maintaining my property. It's my nature reserve, and my family knows that they better keep it when I'm gone. And I will be guarding it for the rest of my life. That's all I can think of. I'm grateful. I'm so happy to do this now.
Are there any members of the public who would like to speak to this application? We will start with anyone attending electronically. Anyone? No, thank you. So is there anyone attending in person who wishes to speak to this application? I do not see anybody here. Are there any questions or comments from the committee to the applicants, the planner, or any persons who have made presentations? Any have any comments?
Amanda, just a quick question. If the license is not surrendered, does that affect the thoughts of the planner on the approval?
Through you, Madam Chair, that's a good question, and the answer in short is no. The accessory dwelling unit is considered an accessory structure, and it wouldn't be impacted by that because residential uses are already established on land.
Are there any further questions or comments from the committee?
Just a question, Amanda. The primary dwelling appears to be smaller than the proposed. Is that correct or not? It doesn't matter.
Through you, Madam Chair. Not to my knowledge, I believe. I have to pull up the report. Perhaps Ms. Gustafson can confirm the intent, but it needs to be at least 75% of the total ground or the total area of the house, which can include any upper levels of the house.
So yeah, so my question is, does the primary building have to be larger or does it really matter?
It needs to be larger, but it doesn't need to be significantly larger.
Right now, the footprint is smaller because I've got a loft in the main dwelling. The new dwelling will just be a bungalow. So the footprint looks bigger, but it's smaller.
So the gross square feet area, when you tally both floors,
use
Without
greater,
objection.
yeah.
Okay, thank you.
Correct.
Are there any more questions from the committee? Thank you. As there are no further comments, would the secretary treasurer please read the proposed conditions for the minor variance?
Certainly. So for this application, they're relatively the standard ones, being that the relief is only for the separation distance for the ADU. That construction will proceed in accordance with the plans provided. That the setback will be staked by an Ontario land surveyor. A building permit will be applied for within 12 months. And if any of those conditions are not met, then the application would be considered void.
Are there any further comments from the committee regarding the conditions? Thank you. Hearing all the evidence before it, is the committee ready to make a decision? Thank you. The secretary treasurer, please read the resolution.
Through you, Madam Chair. Happily, however, I'm not sure that I heard any comments why the application would be either supported or not, and would appreciate certainly any reasons from the committee that we can include in the decision.
Thank you. All the,
I think, Amanda, because of where the driveway is and where the septic is, that the ADU can't get any closer to the original dwelling. So I think that it's appropriate to extend that distance.
Thank you.
thank you. Shall we take a vote? All those. in
I'll just write that down, sorry, and then I'll read the resolution and then we can do the vote. Just give me one second.
Good.
Okay. Moved by Jean Neville, seconded by Paul Radals. Whereas the Committee of Adjustment considered the written and oral submissions relating to application PLMV 2026-033 Gustafson made at the hearing. And whereas it is the opinion of the committee that the relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area, and is minor in nature, and more specifically for the following reason: that the location of the driveway and septic limits the ability to locate the additional dwelling unit any closer, and the relief is appropriate. Now, therefore, it is the decision of the committee that application PLMV 2026-033 requesting the relief from the requirements of bylaw 06-10 as amended to permit the following. From section 4.21 to permit an additional dwelling unit to have an increased setback from the primary dwelling of 50 meters or 164 feet, whereas an ADU is otherwise required to be a maximum of 30 meters or 98.4 feet from the primary dwelling, subject to the following conditions. That approval of the minor variance shall only relate to the proposed new additional dwelling unit, being 50 meters from the primary dwelling, construction of which shall comply with all other applicable law. That construction shall proceed substantially in accordance with the site plan submitted to the township on June 18th, 2026, and put before the committee on July 27th, 2026, and forming part of this decision. That an Ontario land surveyor shall confirm the setbacks in accordance with the approved site plan to the satisfaction of the township. That the building permit, which is to remain in good standing, be applied for within 12 months of the approval of this application following submission to the building department of the appropriate application, fees, and supporting information as required by the chief building official, and that failing any part of the foregoing conditions, this application shall deem to be refused.
In favor? Those in favor? Thank you. It is carried. Thank you very much. And I now declare this matter to be concluded. Good luck. Okay. I now declare this to be a public hearing for application PLMB 2026-034, located in Park Lot 25 in Session 9, Geographic Township of Minden, 1086 Frog Hopper Lane, Sawyers Lake. Would the planner please summarize the proposed variance and any correspondence received to date regarding this application?
Through you, Madam Chair, the township has received minor variance application PLMV 2026-034 submitted by Highland Design on behalf of the property owner Monica Schornweber Carter for 1086 Frog Hopper Lane located on Sawyers Lake. The property is currently developed with a two-story dwelling with attached decks and a two-story garage and shed. The owner is proposing to construct a 60 square meter or 646 square foot one-story addition with covered porch on the east side of the existing dwelling. Staff, in discussion with the landowners about supportability of the application, identified that purchasing the municipally owned Shore Road allowance would increase the lot area and improve compliance with the zoning bylaw. The property owners are intending to proceed with the purchase of the Shore Road allowance and have submitted an application. So the relief from the zoning bylaw does reflect both conditions before and after purchase of the Shore Road allowance. Relief from the zoning bylaw is required as follows. So firstly, from section 5.2 to temporarily permit a 17.8% total lot coverage while the SRA application is being processed, and a 16% total lot coverage upon completion of the purchase of the SRA and transfer of lands on title, whereas otherwise a maximum of 15% is permitted. From section 4.8.41 and 5.2 to recognize a reduced side yard setback of 3.7 meters or 12.2 feet from the southeast corner of the proposed addition to the east lot line, whereas 4.5 meters or 14.8 feet is required. From section 4.9.1 to permit development on an existing undersized lot where additional relief from the zoning bylaw is required. The application is, of course, subject to the four tests of a minor variance as outlined in the Planning Act, which I'll review. The first one being whether the application is minor in nature. The proposed addition will be one story, and together with the existing tree cover will visually blend with the dwelling to neighboring properties. The tree line also mitigates the reduced side yard setback. The proposed location is already a cleared area and a flat portion of the property that is currently used for outdoor parking. Therefore, the proposal does not require significant site alteration or tree removal to accommodate the addition. The existing dwelling is relatively small with respect to ground floor area and will remain a modest size with the addition. The proposed reduction to the setback at the side yard is also limited to the southeast corner of the proposed addition only, owing to the orientation of the existing dwelling. Most of the addition will actually comply with the applicable setback requirement. The application is therefore found to be minor in nature. Opportunities for, second test, I'm just jumping right in. The application is desirable for the appropriate development or use of the land, building, or structure. So opportunities for expansion are limited due to the physical constraints, which are typical of many waterfront lots, including the existing development in this case, which includes the septic and garage, as well as required shoreline setbacks. Being that the proposed addition will exceed the required 23-meter setback from the high water mark, it's not anticipated to negatively affect the condition of the lake, its hydrologic function, or the surrounding natural shoreline. The proposed reduced side yard setback will also not inhibit continued maintenance of the dwelling, particularly as it only applies to a small portion of the actual addition. The surrounding area consists of various lot sizes developed with single detached dwellings and accessory structures. Despite the proposed lot coverage, the development is compatible with the existing physical character of the neighborhood. Reducing the size of the addition would make the additional living space not very functional, owing to both the side yard setback and lot coverage that is being requested. Given the foregoing and where the application is also minor, the application is found to be desirable for the appropriate development or use of land and building. Third test being, does the application uphold the general intent and purpose of the official plan? The subject property is designated waterfront in the official plan, with Sawyers Lake being recognized as moderately sensitive. Permitted uses in the waterfront designation include resource-based recreational uses, and properties on moderately sensitive lakes to maintain existing development rights. The property is sufficiently or significantly deficient in both lot frontage and lot area. The existing lot just meets the minimum requirement to be deemed a buildable lot, and the deficiency has not been previously addressed through site-specific zoning, which is typically required of the official plan. Although in this case, this is a developed lot, so the proposed additional development and increased lot coverage of 17.8% would not be considered to uphold the general intent of the official plan. Purchasing the shore road allowance would increase the lot area by approximately 548 square meters or 5,900 square feet. As the property owners are purchasing the shore road allowance, it is appropriate for the planning review to then consider the additional lands for assessing appropriateness and supportability. The SRA purchase would then reduce total lot coverage to 16% and help maintain the balance of built and natural form across the overall functional property. The property is also located on a point of land shared with other properties, and the angle on which the property is observed from the lake incorporates the existing tree lines, further balancing that built and natural form. There is also a significant elevation change from the shoreline to the developed area, which provides visual depth and helps blend the property and development into the surrounding landscape. Based on this information, it's staff's opinion that the application does uphold the general intent and purpose of the official plan, provided that the shore road allowance lands are purchased. The last test is the application uphold the general intent and purpose of the zoning bylaw. So the subject property is zoned shoreline residential on Schedule 8 of the zoning bylaw, which does permit single detached dwellings. As existing, the dwelling and the deck are considered non-complying, given that the reduced setback to the high water mark is existing to Sawyer's Lake. Otherwise, all provisions of the shoreline residential zone, are being met. The intent of the side yard setback is to maintain appropriate separation from neighboring properties for maintenance and compatibility. The proposed setback provides sufficient room for building and property maintenance, and the orientation of the existing dwelling forces only a small portion of the southeast corner of that addition out of compliance, whereas the rest of the addition will otherwise meet the side yard setback. As well, the application would provide temporary relief to permit the 17.8% lot coverage until the shore road allowance purchase is completed. And then once completed and the shore road allowance is part of the lands, this would reduce total lot coverage to 16%. The maximum lot coverage provision is intended to prevent overdevelopment and maintain sufficient open space to support drainage and land use compatibility. When a lot is constrained by size and configuration, being strict with the application of maximum lot coverage requirements might render even modest improvements or functional additions to a dwelling impractical. As noted, the subject property is generally comparable to surrounding lots. However, due to its location on the point, the side lot lines sort of converge towards the rear of the property, and this results in a slightly reduced lot area relative to adjacent parcels. Given the comparable frontage and depth with surrounding lands, though, the proposed 1% increase in total lot coverage is anticipated to have a negligible spatial or visual impact while providing a practical benefit to the property owner. Therefore, the application is considered to uphold the general intent and purpose of the zoning bylaw, providing again that the shore road allowance lands are purchased. The application is, of course, required to be consistent with the provincial planning statement or the PPS. Under the policies of the PPS, the subject property is rural area, or more specifically rural lands, and permitted uses on rural lands include resource-based recreational uses, and the application would therefore be consistent with the PPS. Notice of the application was circulated to neighboring landowners and commenting agencies in accordance with requirements under the Planning Act on July 16th. The sign notice was also posted on the property. We've received no comments from agencies or the public on this application.
Is the applicant or property owner here today?
Yes, we have Ben DiCarlo, the agent.
attending via Zoom.
I'm not quite sure I heard you. Are we bringing the applicant in teleconference? I'm sorry, I didn't understand. No. Is the applicant here in teleconference?
Yes, he's just, there's
I see.
Mr.
Thank you.
DiCarlo there now.
Yep, good morning.
Please state your name for the record and
Yeah,
provide
it's Ben
information.
DiCarlo of Highland Design. I don't really have a lot to add. Thank you for the report, Amanda. I covered the majority of it off. I just want to reiterate, like that southeast corner, it's roughly 13 square feet of the addition that's actually within the required 14'8" or 14.8 foot setback. So it is a very small portion just due to the positioning orientation of the existing dwelling.
Thank you. Are there any members of the public who would like to speak to the application? And we will start with anyone attending electronically.
We have no one.
No, thank you. Are there any questions or comments from the committee for the applicants, the planner, or any persons who have made presentations? Thank you. As there are no further comments, would the Secretary Treasurer please read the proposed conditions for the minor variance?
Through you, Madam Chair. So again, very standard conditions in this case, so that the minor variance applies only to the one-story addition. That development should proceed substantially in accordance with the plans that were submitted with the application and inclusive of purchase of the shore road allowance. That an Ontario land surveyor would pin the side yard setback, and that the building permit is to be applied for within 12 months. And failing any of those conditions, that the application again would be considered refused.
Are there questions or comments from the committee regarding these conditions? Having all the evidence before it, is the committee ready to make a decision?
I just wanted to comment that the design is very pleasing and blends in very well with the existing building and the small encroachment on the percentage of area impacted shouldn't make a difference as long as the shore road allowance is purchased. So I agree with the application.
We agree. Thank you. So hearing all the evidence before it, is committee ready to make a decision? Would the Secretary Treasurer please read the resolution?
Absolutely. Just writing out what Jean said for the decision. Just give me one second. Okay, I'm ready. I was a little bit faster that time. Moved by John Agate, seconded by Paul Radals. Whereas the Committee of Adjustment considered the written and oral submissions relating to application PLMV 2026-034, Sharon Weber Carter, made at the hearing. And whereas it is the opinion of the committee that the relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area, and is minor in nature, and more specifically for the following reasons: that the design blends in well with the existing building, and that the small encroachment into the side yard should not make a difference, providing that the shore road allowance is purchased. Now, therefore, it is the decision of the committee that application PLMV 2026-034, requesting relief from the requirements of bylaw 06-10 as amended to permit the following: from section 5.2 to temporarily permit a 17.8% total lot coverage, while the SRA application is being processed, and a 16% total lot coverage upon completion of the purchase of the SRA and transfer of lands on title, whereas otherwise a maximum of 15% is permitted. From section 4.8.41 and 5.2 to recognize a reduced side yard setback of 3.7 meters or 12.2 feet from the southeast corner of the proposed addition to the east lot line, whereas 4.5 meters or 14.8 feet is required from section 4.9.1 to permit development on an existing undersized lot where additional relief from the zoning bylaw is required, subject to the following conditions. That approval of the minor variance shall apply only to the proposed one-story addition having a ground floor area of 60 square meters or 646 square feet, and that construction shall comply with all other applicable law. The development of the subject land shall proceed substantially in accordance with the site and building plans submitted to the township on June 24, 2026, placed before the committee on July 27, 2026, and forming part of this decision, inclusive of the purchase of the municipally owned shorewood allowance as per application PL SRA 2026-036, that an Ontario land surveyor shall confirm the setbacks in accordance with the approved site plan to the satisfaction of the township, that the building permit which is to remain in good standing be applied for within 12 months of the approval of this application following submission to the building department of the appropriate application, fees, and supporting information as required by the chief building official, inclusive of any documentation as it relates to completing the purchase of the shorewood allowance as per application PL SRA 2026-036, and that failing any part of the foregoing conditions, this application shall deem to be refused.
All those in favor? Thank you. It is carried. I now declare this matter concluded. Thank you. Any new business to discuss?
Through you, Madam Chair, I did have one item that I wanted to bring forward to the committee. We've encountered a couple of instances where we require an acting chair to step in. And as the committee knows, we do then have to sort of change our normal process as a little bit more of an administrative process. So I'm suggesting that for sort of ease of process, that we might want to appoint a vice chair. So in the case where the chair is not available for any reason, that the vice chair would just automatically step into that role and we wouldn't have to go through those extra steps at the beginning. So looking to the committee for thoughts on that matter, as well as anyone who might want to volunteer. I know, Honoree, you usually do step in as acting chair, which we always appreciate. It is certainly open to anybody, but I do acknowledge that Honoree has been quite helpful in stepping in when needed.
For a discussion, I'm happy to step in whenever I'm available, and I'll try to be, but if someone else would like to. Well, is that enough for you, Amanda?
Sorry, couldn't hear if there's anything going on other than Honoree, you offered to step into the role, but I didn't hear if anybody else said
Yes,
anything.
I think we all agreed that we should appoint Honoree as our vice chair.
Okay, sounds good.
Thank you very much.
So then I will read the resolution if that's all right with you, Honoree. So, Madam Chair, moved by Jean Neville, seconded by Paul Radals, be it resolved that Honoree Tall is hereby appointed as Vice Chair for the Committee of Adjustment for the remainder of the term of council.
Is there any more new business? I'm sorry. All in favor? All right, is there any more new business to discuss?
Not for me.
No? So when is the next meeting, please?
So we will have a meeting on August 31st.
Would the Secretary Treasurer please read the resolution to adjourn?
Certainly. Moved by Jean Neville, seconded by John Agate. Be it resolved that the Committee of Adjustment meeting be adjourned at 10:09 a.m. on July 27, 2026, and the committee will reconvene August 31st, 2026.
Those in favor? It's carried. Thank you.
Thank you, everyone. Have a great day.
You too, Amanda.
Thank you.
On holiday?
Yes.
Enjoy.
Thank you.
Looks like you're still working though.
Always.